Kuika kina pijashig Anush Fraser Terjanyan Nidijnakas
Nakishep
Ottawang
Anush
Nidonjiba
Fraser Terjanyan Nidijnakas
Scotland, Malawi, Ashid,
Kitchenendon
Gurun, Aleppo, Armenia,
Mampi
Nidonjibamin,
Hiaik Nungo Mandagisco
Ottawag, Gracefield, Nindab.
Kotona Nekogi Katochik.
Good morning, all, and welcome. My name is Anush Fraser Terjanyan, and I'm honored to welcome you, all 413 of you apparently, and honored to be present
New
today
York from Laswa Kidik Nikan Ching Mampi
as an uninvited guest on unceded Algonquin Anishinaabe territory
Mampi Nam
for a conversation
Algonquin
with my dear colleague, Brenda McDougall, and our distinguished guest, Dr. Bruce McIver, on the occasion of the Ottawa launch of his important new book, Standoff. This event is the product of a partnership between the Institute for Indigenous Research and Studies and the Human Rights Research and Education Center at the University of Ottawa. Vous pouvez suivre cet événement en français. Pour ce faire, je vous invite à cliquer sur le bouton qui est marqué sous-titrage. You can follow this event in French by clicking on the button that says CC Live Transcript. You can also follow this event in Ojibwe. You can also follow this event in Ojibwe by clicking on the globe at the bottom of your screen and selecting Ojibwe. I'm speaking slowly because I want to give a chance to our interpreters to have time to write. J'aimerais commencer avec l'affirmation autochtone de l'Université d'Ottawa. Nous rendons hommage au peuple algonquin Anishinaabe, gardien traditionnel de cette terre. Nous reconnaissons le lien sacré de longue date l'unissant à ce territoire qui demeure non cédé. Nous rendons également hommage à tous les peuples autochtones qui habitent Ottawa, qu'ils soient de la région ou d'ailleurs au Canada. Nous reconnaissons les gardiens des savoirs traditionnels, jeunes et âgés, et nous honorons aussi leurs courageux dirigeants d'hier, d'aujourd'hui et de demain. I now have the pleasure of introducing an honored friend, Dr. Bruce McIver. He is the author of the new book we will be discussing today, Standoff: Why Reconciliation Fails Indigenous People and How to Fix It. Bruce's biography and its various iterations and components factor as key elements of the arguments in Standoff. And we can discuss these later on in our conversation. Here's the version offered by First Peoples Law, the firm Bruce founded. Bruce's ancestors took Métis scrip at Red River in Manitoba. He holds a law degree, a PhD in Aboriginal and Environmental History, and is a Fulbright Scholar. And Bruce is a member of the Manitoba Métis Federation. Our own Professor Brenda McDougall is the chair of Métis Research at the University of Ottawa, where she also serves as the academic delegate for Indigenous engagement. She is also a fellow of the Royal Canadian Geographic Society and a member of the Royal Society of Canada's College of New Scholars, Artists, and Scientists. Welcome to you both. Bruce, I'd like to start with the following question. The overarching theme of your book is reconciliation and its discontents. As I read, I was reminded of the lines of the poems by Henrik Maria Rilke that was also made famous by the English settler Canadian author Hugh McClellan. Love consists of this: two solitudes that meet, protect, and greet each other. Of course, McClellan mobilized this tension or possibility to talk about the possibility of reconciliation between Canada's two solitudes, understood solely as Anglophone and Francophone, a proposition which in many ways was transformed at the time too into a statement of the impossibility of reconciliation, but also a proposition which ignored and erased the presence of Indigenous rights holders. So I'd like to open then by asking you and Brenda both, but you especially first, Bruce, to start, about this concept of reconciliation. What does it mean to and with Indigenous populations? What should it mean? There's a vernacular, and then there is the legal torque, this house of cards, as you call it in your book. And what is the connection to peace? Bruce.
Thanks, Anusha. Thanks, everyone, for joining today. I'm really honored by your presence, and I just want to say thanks to everyone for helping organize this, and particularly thanks to Henry for the translation. I was attending a law conference in Vancouver a couple of weeks ago, and it was about Indigenous rights and Indigenous laws and everything else. And it really struck me that there was no translation into an Indigenous language at that conference. And so I'm really honored to have that as part of this. And my sincere thanks to Henry for making himself available and to doing it. In response, my first thought was the discontents. I guess I'm probably one of those. I'm going to have to get a little label to wear around, one of the discontents. I've not thought of myself as that before, but that's a badge I'll wear with honor. I think the best way, if it's okay, Anusha, to speak to this, what my central thoughts are. I'll just read a short piece from the book that sums up what my thoughts are on this. And for those who have not seen the book yet, this is pretty typical. They're all really short essays, probably about 800, 1,000 words. So don't worry, I'm not going to bore you with some long reading. The best compliments I get from people when I do these types of readings and talk about this is that they really enjoyed it. You didn't sound like a lawyer. So hopefully that's what some of you think about this one. This one's called Reconciliation as a Massive Failure. I was thinking about it. I guess I kind of give it away in the title what my view is, but this is what this one says. Anishinaabe comedian Ryan McMahon is one of Canada's most perceptive social commentators. Season 5 of McMahon's Red Man Laughing podcast is devoted to reconciliation. In his view, the brand of reconciliation peddled by Canada's mainstream politicians is a massive failure. For many, McMahon's critique likely grates on the ears. For those willing to be nudged out of their comfort zone, McMahon's criticism rings true. Reconciliation continues to fail because it rests on a foundation of systemic racism. It is predicated on the denial of Indigenous peoples' inherent rights and the willingness of the Canadian state to use violence to suppress Indigenous rights. Reconciliation continues to fail because it attempts the impossible. The reconciliation of a right with a lie. The lie is the pre-existing interest Indigenous peoples had and continue to have in their land, and the right to make decisions about their land before the colonizers arrived. This includes the right to benefit from the land and decide how the land should be used or not used. The lie is that through simply showing up and planting a flag, European nations could acquire an interest in Indigenous land and displace Indigenous laws. Around the world, this racist legal principle is recognized as the doctrine of discovery. It was developed by the United States Supreme Court in the 1830s. In the Supreme Court of Canada, 1990s parallel decision, where the court articulated for the first time the fundamental principles for interpreting Section 35 of the Constitution, it was welcomed as an essential principle of Canadian law. While the doctrine of discovery was codified as part of Canadian law, its rationale is nothing new for Indigenous peoples. By the time the court codified it, it had become all too familiar to them. For decades and generations, they had been faced with the denial of their laws, of their title to the land, of the true spirit and intent of treaties, of their very humanity. Denial is the handmaiden of violence. When grainy images hover on TVs and computer screens of Indigenous peoples assaulted by agents of the Canadian state, the legacy and modern reality of denial upsets smug complacency. In that discomfort, the opportunity for real reconciliation is born. Confronted with the reality that rote, feel-good land acknowledgements are part of the problem, not the solution, Canadians will hopefully start to demand deliverables. What are the courts and mainstream politicians doing to undo hundreds of years of violence and denial? What is being done to ensure that Indigenous laws are respected, that Indigenous peoples benefit from their lands and are actively involved in deciding how their lands are used? As hard as it might be for Canadians to hear McMahon's condemnation of reconciliation as it is currently practiced, his criticism is also an invitation. It is an invitation to Canadians to take the first step on what will undoubtedly be a long and difficult road. The first step is acceptance. Acceptance that Canada is fundamentally a racist state, that it has been built on the denial of Indigenous people's rights and humanity, that this denial is a shameful fact that runs through and binds together Canadian law. With acceptance comes opportunity.
Thank you.
Thank you.
Thank you very much, Bruce. This is a beautiful way to begin with this framing, which is one of diagnostic of the serious problems, but also within this title of that chapter of your book, that reconciliation is a massive failure. I cling to the moments in which you suggest that there are paths to opening. I'd like to turn to our colleague Brenda to ask her to help us flesh out the thesis that Bruce has offered here, and to offer her additional comments or ideas to the conversation.
Well, hi everybody. Thank you for coming. And I'm really excited to get to a chance to chat with Bruce. And I hope that this sort of evolves as a bit of a conversation. And thank you to the simultaneous translators. I know how important it is, and I can see in the comments how warmed everybody is to hear Ojibwe being spoken as part of this. So hi. So the very concept of reconciliation is really about putting things to. It's about bringing together people in shared understanding of something that has happened, and Native Indigenous people in Canada don't really have anything to reconcile over. We haven't done anything to create this discord. And so really what we're talking about in many respects has to be conciliation, which is putting things to right. And until we sort of face that concept of we need to put things right because of these concepts that both Ryan and Bruce have put forward about systemic racism, denial, and violence, Canadians tend to think of themselves as a place living in a country that is built on peace and good governance and justice, and that Americans have somehow been fundamentally more violent in their approaches to indigeneity. And I think what we're exposing at this point is that violence is universal in North America. And until we actually address all of that and start talking about how to put things right, as opposed to reconciling, we'll continue to be at loggerheads about what it is that we're trying to engage in the first place.
Wonderful. Thank you, Brenda. To build on those ideas, I would like to point the audience to many parts of Bruce's book where he problem solves on some of the attempts that have been made in the Canadian context to address this challenge of conciliation. And I would go beyond conciliation to suggest the challenge is one of basic social justice that aligns with a human rights discourse that is shared often as well in Canada. Especially as coming here as a proud, with my cap on as the fellow at the Human Rights Center, a point that I'd like to make in a very important way. So can we try and build on one of those attempts? It's something that you cover in your book, Bruce, and that is the passage in December of last year by the Canadian Parliament of legislation surrounding Canada's implementation of UNDRIP being the UN Declaration on the Rights of Indigenous Peoples. You have a chapter of your book in which you refer to this as the cold rain. And I wonder if you could help us talk about or understand better your position on the limits and possibilities of UNDRIP. Thank you.
Sure, thanks. Before I get there, I just want to build a little bit on what Brenda had to say, and I'm really thankful for that. There really does need to be this change, like this fundamental change. One of the frustrating things I witness all across the country is the institutions of the Canadian state still not coming to terms with their racist basis. And it's not something about the past, it's something about the present. That's what makes it so difficult. It's just something that happens on a daily basis in this country. I found myself on a telephone call with Mi'kmaq clients and representatives of the RCMP last week. And a lot of you tuning in will be aware of what's been happening again in Wet'suwet'en territory. Watching that horrifying video of the RCMP, the agents of the Canadian state breaking down a cabin door with axes, dogs barking, sniper rifles. And with that in all our minds, I'm there hearing a presentation from the RCMP speaking to Mi'kmaq clients who have witnessed that themselves, whether it's around trying to exercise their constitutionally protected fishing rights, whether it's trying to stop fracking on their territory. And what do we hear from the RCMP? We embrace Gandhi. Be the change you want to be. And someone working in this field all the time, like, where do you put that? I don't understand the cognitive dissonance that's going on. If that's what's happening, we're a long ways from any form of reconciliation. So I just want to highlight that, because I think if one of the things I can hopefully contribute is that my experiences working for Indigenous people on the ground all across the country, it can be very frustrating at the Supreme Court of Canada hearing questions from the court. It can be very frustrating reading court decisions because you can identify that disconnect. And I think it's important that lawyers, judges, politicians, everyone understand there's this huge disconnect. So on that point, the UNDRIP legislation, I think, is another example of a huge disconnect. I've written about this in the book. There's two fundamental problems that I see. First of all, it's not like there's a lack of legal standards that the provincial and federal governments should be held to. Those have existed in Canadian law. The concept of consent goes back at least to 1763 in the Royal Proclamation. It's not new. It was referred to in the 1997 Delgamuukw decision. So that's been part of Canadian law. The problem is not a lack of legal standards. It's a lack of governments being held to account to those legal standards. So that's the first point. The second one is that the federal legislation and the BC provincial legislation are interpreted by governments as being aspirational documents. I don't know about the people participating today, but I know for myself, and I know a lot of my friends, family, colleagues, clients, we're sick and tired of aspirations. This needs to be done now, and the provincial legislation in BC is a good example. I think a fair reading of that legislation is there's an obligation now to uphold the principles in all decision-making, not simply an obligation to change the laws into the future. Thank you.
Excellent. I don't know, Brenda, if you wanted to add anything to this dimension. It's Bruce is making a very important point about coherence ultimately, and failure in the failure in argumentation and in coherence. I don't know if you have something to add to that.
Well, I'm not an expert on UNDRIP. I mean, I've been hearing about it for years, but I think UNDRIP, as well as all of the other pieces of legislation that we're talking about in relation to human rights, are, rights are granted by states in many respects. And we're talking about a set of rights that are being agreed on by different types of peoples and states and national entities. And if somebody is granting rights, somebody has the right to take them away. And I think one of the things that we're not talking about is responsibility. We're not talking about obligation. And these are important concepts in our worldview. And if we're going to have honest conversations about where Indigenous people are going to stand in the world, part of it is that our sense of self and worldview has to be a part of that conversation. There can't be a disconnect between those things any longer. And as I'm currently experiencing it, and maybe that's just my experience, is that human rights is something that is working against us in many respects, because human rights are about the individual. And what is happening in land back concepts or in the collective efforts of Indigenous peoples to protect their land, their space, their humanity is collective, not individual. And so part of the cognitive dissonance is between the Western idea of individuality and our sense of our collectivity. And that's where we're not connecting, because we're not having the same conversation.
Those are very important points. It's a kind of in concept of a dialogue of the deaf, and it reminds me of a term and a concept that I would even amp it up to introduce this concept of Lindsay McGooey's, that of the notion of strategic ignorance, right, as well, because there's a refusal. What you're suggesting is not just a refusal to recognize or to respect, but also a refusal to even acknowledge and to know what is should be readily apparent. You know, I think that there is I want to keep on this diagnostic front, and I want to make sure we have lots of time for questions. I see the chat is on fire, and I want to thank all of the audience members. Encore une fois, si vous êtes là et vous êtes francophone, on vous invite à ouvrir le sous-titrage en bas de votre écran pour pouvoir participer à la conversation en français. N'hésitez pas à demander vos questions en français. Nous allons les traduire aussi, et vous êtes les bienvenus. And again, as a reminder, if you've just come on, that we have live, in addition to French translation offered by the wonderful Anne-Marie Tudorache, we also have live interpretation in Ojibwe by Henry Pitawanakwat. So we want to thank our friends who have helped with this. I want to pick up on this point that you raised, Brenda, which is these different concepts of understandings of the self in relationship to others, and of the self in relationship to governance and otherwise. And there's a very, I felt, extremely moving piece in Bruce's book called Indigenous Identity and the Canadian Law. And it builds on what you're talking about, Brenda, which is that it's hard to extricate these concepts of identity from this conversation of the deaf, or any attempts to try and find a space for conciliation or justice in Turtle Island. So I wondered, Bruce, if you could tell us a little bit about that chapter, the connection you make between Indigenous identity and the Canadian law.
Well, I think one of the ways to do that is to describe an experience I had last week. I decided to sit down over a cup of coffee, I don't know what I was thinking of, and do a Venn chart. All of you are familiar with those Venn charts, the overlapping circles, seeing how different groups relate to each other. So I got an idea, why don't I do a Venn chart about Indigenous identity. And this is something I've worked in for years and years. I was surprised what an intellectual challenge that was. I spent almost an hour trying to draw up this crazy Venn chart, laying over status, non-status, identifying as Métis, having Métis rights under Section 35, being an Indian within Section 9124. It was quite the intellectual challenge, and I sent it off to one of my staff and said, now that I've drawn it up, can you put it together as a chart? And she did, and I look at it now and I'm still struggling to understand how all these things work together. No wonder non-lawyers have a hard time figuring this out. But I think the number one lesson from that, not all, but most of those circles that I had drawn to overlay identity were circles created by Canadian law and the Canadian state. For my clients, who they are as a people isn't that difficult. They know it. They know who they are. They have their own laws, practices, defining them as a nation, but it's that overlaying of the Indian Act and then the Supreme Court of Canada decisions. I write in the book about the Daniels decision on the Métis and Indian status under one part of the Constitution. That's caused incredible confusion. People all across the country. So I think one of the things to keep in mind about all this is that if it seems confusing, particularly to non-Indigenous people, it's no fault of Indigenous people. They don't have any confusion about this. This is the result of colonization and ongoing colonization. So just for a final point on this, and this is why it's really important not to use that against Indigenous people. I've heard that in the Wet'suwet'en situation, where you'll have commentators, politicians referring to Indian Act Chief and Council, members of a, quote, First Nation, which they really mean on a banned list created by the federal government, and using that to some extent, I think, to sow decision and confusion. I think that's really important that we're aware of it and we resist it as much as possible. Thank you.
Excellent. I want to keep us on this vein of still trying to think about the problems that we're contending with. And before moving to questions, I'm hoping we can start questions at around 2:15, and I'm trying to monitor the chat as well, but we'll invite you to start preparing your questions, invite you to do that. On vous invite à inclure vos questions. On va commencer, on va vraiment offrir une opportunité environ de 45 minutes pour des questions. But so to keep on this diagnostic frame of the problems, and then I'd like to move to a very important part of your book as well, which is in the subtitle, How to Fix It part. Bruce, which we can ask you to tell us in all of 5 minutes. But I want to keep on this diagnostic thing, because there's another very provocative piece that I think is very important, especially in a university setting, that you've written, which is called "Made of Sterner Stuff: The Problem with Allies." And I'd like you here again to kind of open the curtain, pull the veil, all of these different metaphors to tell us a little bit about what the content of that essay is.
Yeah, I think the best way to do this one, I'm just going to read this one because I was very careful in how I wrote it. And this one, I get a lot of feedback from academics across the country on And I'd be interested in Brenda's views on this. So I'm just going to set this up a little bit. My favorite, or one of my favorite poets is Philip Levine, and there's a part of one of his poems called The Poem of Chalk that I had rattling around in the back of my head when I wrote this piece. And it goes, he knew the sadness of classrooms in December when the light fails, early, and the words on the blackboard abandon their grammar and sense, and then even their shapes, so that each letter points in every direction at once and means nothing at all. Allies depress me more than opponents. Many who outright disagree with me about respecting Indigenous rights are open to persuasion. I don't include the committed racists in this category. I'm talking about those whose opinions rest on a lack of information, context, and empathy. If I listen to them honestly and without judgment, they often do the same for me. When they realize I will not ridicule them for their opinions, they become more receptive. They begin to acknowledge that I might have a point. Maybe they should have a rethink. For example, several years ago, I spoke to a group of people working in a resource extraction industry in Northern Ontario. As expected, I didn't receive a warm reception. For an hour and a half, I fielded questions and comments I hear on a regular basis. Why can't we all be treated equally? Indians don't pay taxes. Don't your clients want to work? After explaining that my clients do in fact pay taxes, that they are the hardest working people I know, and why all Canadians should be proud the Constitution protects collective rights, many, but not all, began to reconsider their received opinions. By the end of the session, their hostility had been replaced by friendliness and a greater understanding of the legal and historical context for recognizing Indigenous rights. I left the room exhausted and hopeful. In contrast, allies can move me to tears. I'm not referring to the vast majority who are well-intentioned and committed to doing their best to understand a complex issue and play a supportive role. I'm not even referring to the minority who indulge in performative allyship. They are easily recognizable and increasingly find themselves without an audience. The people I have in mind are the handful of allies perfectly suited to be cast as judges in a game show entitled Defend Your Life. Usually well-educated and comfortably white, buoyed and insulated by entitlement and privilege, they rush forward with opinions, criticisms, and superior insights, unburdened by doubt or humility. I often encounter these people when my criticism touches their core understanding of what it means to be Canadian. On the second anniversary of the acquittal of the Saskatchewan farmer who killed Colton Boushie, I gave a talk to a group of allies about the systemic violence perpetrated against Indigenous people by non-Indigenous Canadians and the Canadian state. It was a difficult talk to give. Professionally, we had just witnessed the RCMP's arrest of our Wet'suwet'en clients. Personally, It stirred memories of growing up in rural Manitoba. At the end of my talk, an ally rushed forward to challenge me. The nub of his rebuttal was, Indians killed Indians before white men arrived. Looking around the room, I noticed one of Colton's cousins, eager to speak to me, but blocked by this domineering ally. I struggled to distance myself from him and contain my emotions. I was being corrected, put in my place by a white man, confident not just in his opinions, but in his right, and from his perspective, his obligation to school me. I felt myself back in grade school, a kid without privilege, confident in my family's support, but constantly reminded of my position on the margins of respectability. At some point in high school, I realized that questioning had limits. A line existed between acceptable, polite criticism and the unspeakable. The national myth of Canada the Good was sacrosanct. Cross that line and you risk being disciplined, punished, cast out. Some allies do more than act as self-appointed arbiters of acceptable discourse. They strive to establish themselves as stronger and more determined than those they purport to support. 2 days after news emerged of the bodies of 215 Indigenous children discovered at the Kamloops Indian Residential School, I was about to sit down for dinner with my family, knowing that clients and friends and family members across the country were struggling with loss and grief. I was engulfed in a fog of sadness and despair. Unthinkingly, I opened the email on my phone. Waiting for me was an email in reply to an essay I had published 9 months earlier, the one I read to begin this talk. The writer was a self-described member of a well-known national nonprofit organization dedicated to dismantling racism and colonization. The tragic news from Kamloops had motivated him to reach out to me. He had a problem with my use of the word acceptance in the second last paragraph when I wrote the first step is acceptance. Acceptance that Canada is a fundamentally racist state. In his view, I should have used acknowledge because the word is, quote, made of sterner stuff. For my edification, he helpfully included dictionary definitions. I had never cried in front of my kids, but in that moment, slumped over the table with my head in my hands, I cried. I cried for the 215 children and their families. I cried for all the stolen, abused, and murdered Indigenous children across Canada. I cried for my lack of words to explain any of this to my children. I cried for the marginalized, oppressed, and abused whose voices are stolen and silenced by their allies. Thank you.
Thank you, Bruce. You know, in French, there's an expression, je suis sans voix, I am without voice. Listening to you, and it's a very important and powerful indictment. And you would like to invite Brenda to add her reflections.
There's so much to unpack here, and trying to pick a particular approach is probably the harder piece. There's a couple of things that I guess I want to say. You know, we experience allyship in university settings all the time, and my example of this is along the lines of thinking about how and where Indigenous people should be and where they can be accepted. And so the current trend of universities is to, you know, every department, every unit wants an Indigenous colleague. It's sort of like a, you know, a collector's piece. If we've got one, then we've solved the problem of political studies or of history or of English. And wouldn't it be great to give students access to all those things? And absolutely, it's true. But those allies who want those people are also the people who undermine Indigenous specific programming, Indigenous studies departments, Indigenous governance programs, because that's ghettoization or segregation, as opposed to a space where we can actually engage and discuss the things that are actually about us in ways that we want to theorize from our languages or our traditions or our worldviews or our ceremonies. And there's no space then for that to happen, as long as we're all split up and spread across the campus in so much the ways that First Nations people were separated and spread through the reserve creation process in Western Canada, or the lack of recognition of a common home base for Métis people in 1870. And these ideas of racism and white supremacy, which Canadians are so uncomfortable with. And I will admit, there was a time in my life when I was uncomfortable with those words because I thought they belonged to South Africa, or I thought they belonged in the United States. They didn't really, because I went through the same educational process that told me that Canada was far more benevolent. But we have Indigenous scholars and leaders and thinkers who have been talking about this and who have been writing about this since the 60s, the 70s. And so I'm going to name them because I think we need to remember that people have been doing this for a long time and we owe them a great debt. So people like Howard Adams, Maria Campbell, Harold Cardinal, Harry Daniels, Duke Redbird, George Manuel, and I'm missing so many others who probably all of you could name in the chat that I'm, you know, they're not at the tip of my tongue right now. We have a lot of people that we can look to for the words and for the expressions that we're talking about and trying to express now. Vine Deloria, absolutely. Please keep adding their names. But, you know, if we can't have space inside a university to exist as Indigenous people, but we have to fit inside the mainstream, we're going to continue to be unsuccessful in what we're doing. And so that's where I'm at. That's the institution I've been working in. That's the context that I have to work with in terms of trying to understand some of what's happening around me.
I don't know if you want to add, Bruce, or if.
Well, it's interesting because my own career path, I was intending to be a university professor myself. It was when I was finishing my dissertation that I was one of, and I'm sure a lot of people here who know these people, it's one of those people as a graduate student had gotten a lot of scholarships and fellowships, but I never got around to finishing my dissertation. And so the time was getting short and I finally had to get it done, and I finally had to find some money to pay for it. So that was how I ended up working with some of the best Aboriginal law lawyers in Canada, in Vancouver. And it was doing that work with them that I recognized for the first time there's a way to serve your community outside of academia. And while there are a lot of minuses being a lawyer, I'm not trying to gloss it over. There are certain challenges. On a whole, I find it, for myself at least, much more effective. And one of the reasons I find it more effective is that if you are a good lawyer, you are working for your client. That is the number one thing. Everything you're doing is to affect change on behalf of your clients. Whereas I always found it challenging in academia because it's, why am I doing this? What conversation am I part of? And how is this going to affect change? And I see a lot of Indigenous people, not just Indigenous, but a lot of Indigenous people turned off because of that. There is a sense of service. There's a sense of continuing that tradition, which we're talking about. I was just about to add some more names into the chat. You know, I had so fortunate to spend a bit of time with Harold Cardinal before he passed. And those people, like, I always see the work we do as building on the shoulders of those giants, right? Just amazing. And we're here to help move the ball down the field a little bit while we can. We're not solving anything. I'm certainly not solving anything. And then pass it on. And the passing it on is really important. I've always found my experience in academia is that there can be a shortage of understanding of the responsibility to pass it on to another generation. And that's important. That's what we're doing. And I really think we owe it to the future to be actively doing that.
I think it's an important moment for us to try and think before we see there's questions coming in the Q&A, and I wonder if colleagues, you know, if Bruce and Brenda, you would might be interested in answering some of those. I do want to make sure that we don't leave without talking about this last phrase, Bruce, because I think it's an important part of your book as well. Which is that we're not just, you know, often in universities, we spend our time in a position of critique. And the comment you've just made is about action and repair, right? And so I think it's important also for us, since this is a university-based element of your book tour, to spend time on your advice about what you see as possibilities to open up. So but I would like to turn to some of the questions before we get to that part. And early on, actually, Sandra Thompson's raised this point about one of the first questions that came up about Dale Turner's argument that Canada is an illegitimate nation. I think she raised it in the chat. And I was wondering, you know, we're having conversations right now related to the Barbadian Republic announcement about the relationships of certain Indigenous populations in Barbados to the Crown and otherwise. And I wondered if you could tell us a little bit about what you see as, you know, what your take is on these issues and on this question.
To be frank, I'm not exactly sure what the question is on that one, but I will talk about the fix-it thing, because I know that's part of what we want to talk about. Not that I have answers on this, but I do think there are a few basic things. First of all, I have no time for politicians that get up and say, sorry, it's all too complicated, we can't fix it, or it's going to take generations to fix it. I was asked that a while ago about the land back movement, and Minister Miller saying, we want to do it, but it's really difficult and complicated. And I think it's important to put that complexity in context. It wasn't hard for non-Indigenous people to show up and claim the land. They found that pretty easy to do, planting a flag. And second, and this is something that's going on, particularly in the prairie provinces, it's not hard for the provincial governments to sell it off. They're doing that left and right, Treaty 6, 8, 4, 3. They're selling it off. So they don't seem to have a big problem doing it. And I think that's important. When you hear from politicians, it's hard to fix. It's not that hard. One of the things, and going back to Wet'suwet'en again, is to get away from this reconciliation paradigm. I think that's part of the problem. We need to move to recognition, not reconciliation. Recognition, and the Canadian state following its own laws. It's one of the frustrating things. The example right now at the forefront of my mind is what's going on in BC. Again, with the Wet'suwet'en. We're in that situation of the RCMP enforcing an injunction because the provincial government continues to deny Wet'suwet'en title. That's why we're there. For 150 years, they've been doing it. They continue to do it. Because they continue to do it, the legal obligations on them are weak. They are duty to consult obligations. And that leads to an injunction as a direct path. If the provincial government stood up and said, we recognize Wet'suwet'en title, it exists. We don't need a Supreme Court of Canada declaration. It exists. And in fact, it's important to keep that in mind. Title doesn't suddenly pop into existence because a court in Canada says it does. That's not, it's there, it's inherent. It's just not been recognized, it's been denied. If the provincial government recognized it, which they could do tomorrow, the legal obligations on them would be much higher. Then we would be in a world of consent, of justifying infringements under Canadian law. It's their reluctance to do that that puts us in the position we're in now. Thank you.
So this is an important point that relates to, I'd like to go to some of the questions in the Q&A. One of our colleagues early on who watched asks if there are examples of public governments that you can give that respect Indigenous law and practice. It's building on, your point that actually there are too many examples of public governments that don't respect Canadian law. But I think it might be an interesting point to start, if you'd like to address that one.
Well, this is some of the most important work being done across the country, and it's being led by Indigenous people. It's definitely not being led by governments. It's Indigenous people in the long line of the names we've been seeing in the chat, continuing on the fight and saying we're fed up with simply talking about Canadian law. Our nations have our own laws. They need to be respected. So they're leading that. I think that's the most important work that's being done. There's a role for the courts to play there. Importantly, this is totally compatible with the Canadian state. It's important to keep in mind, Canada is a confederation. We have provincial and federal laws interacting all the time. We have the tools to deal with that. The issue is that it's not applied equally to Indigenous laws. And it can be, it should be. There's ways to do it. I have no time, as I say, I'm sorry, we can't. Yes, we can. And not only can we should be doing it. And when I hear politicians, corporations, certainty, we need certainty. If you want certainty, that's the way you get certainty. Why, I think, and I hope I don't come across as being cynical, but it's hard not to think that why it's not being done is not because of a lack of law. It's because politicians see that, well, this could endanger resource development projects. And we can continue to push those projects through. And it's that type of short-term thinking that leads to the confrontations we continue to see all across the country.
Just to
Brenda, would you like to add? Yeah.
Yeah, just to add to what Bruce is saying, back in when we were having constitutional debates, I heard regularly that, we can't have Indigenous peoples as, a fourth order or a fifth order of government because, we can't have competing legal jurisprudence in this country. Well, we've got droit civil or, French civil law, and we've got English common law. We have dual legal systems already. And as Bruce is saying, we have mechanisms to manage that because we operate in this context legally already. Our Constitution has it baked in. So to add another set or a series of forms of law does not undermine Canadian anything. In fact, it reflects the way that Canada currently operates. So like Bruce, I find this to be kind of a nonsensical non-starter, except that governments and citizens really have this baked into their head that somehow this is too complicated to manage. In the same way, we would never have had a form of simultaneous translation in Indigenous languages because, we're only set up for French and English. And yet, look, it's working brilliantly.
Wonderful.
It's an extremely important point. And I would like to add, it's a very interesting, important burden right now because we are all using a platform called Zoom, which only allows one transcript to happen. So it comes from a space which is aggressively unilingual in the United States, and where there is no openness to plurality of language. And I know that we had this conversation before starting, that it's a very important issue, the barriers, technological and otherwise, to inclusion. So we're all trying with the first step to do what we can, and it's definitely not enough. Let me see if there's another question here. There is a question from George Kirby, who is asking a question about Section 92, which grants permits of tenure on unceded territories in BC. Can non-surrendered First Nations sue under Section 91, I believe, for breach of fiduciary duty? Bruce, you're smiling because maybe this is something you've been working on recently, and sue for past trespass and theft and willful damages on ancestral homeland. So, Bruce, and again, and how does a House group of a nation stop the Indian Act bureaucrats from surrendering ancestral homeland? And this is the land grab question that you alluded to earlier on. So if you could help, first of all, translate that question to us in less legalese. We need another caption from the legal to the English here. That would be wonderful.
Yeah, thanks. Thanks, George. A good question. I'll try to capture that as best as possible. There's a lot of layers to it, and I'll just start with the typical lawyer caveat. I'm not giving legal advice, but just for information purposes, the short answer is yes. Yes, you can sue on those things. Some of you will have seen what Listaquay in New Brunswick this week revised their Aboriginal title claim to sue not just the provincial and federal governments, but sue companies directly. So that is definitely something you can do. Second, and I remember arguing this around the Supreme Court of Canada case, even on the duty to consult, you can still go back and sue. And importantly, there was a really important case, one from Quebec and one from the BC a few years ago. You can sue, you don't even need to sue the provincial and federal government. You can sue companies themselves directly for infringing rights. I think part of where we're going is the law is going to develop in this way, because at the end of the day, are we getting a real tangible result for Indigenous people? I always tell clients when we're doing duty to consult work, which I do a lot of, what are we going to get at the end of the day? Unfortunately, a lot of times you end up like Charles Dickens, you know, get more gruel, please. You know, is that really what we want? Is more of the same? More consultation? Thank you so much for that. Yes. So my answer is, George, yes. And this is where the law is going to develop. And it's Indigenous people, again, that are shouldering the load to develop it in that direction. It'll be good for all Canada, because once those results, those remedies are well identified, there will be more impetus on companies and government to take part in true recognition of title.
We have a question from Wendy Hawks, which is related to some of your earlier points. Again, it's this theme about enforcement of laws, right, and the legality of regimes. And here she asks, in alignment with the point that Brenda made, she asks about the potential for First Nations forming their own Supreme Courts. Now, you have a chapter in your book. I'll take this moment to lob you this one as well. You have a chapter in your book, and here we are, everyone. I just want to take a moment to remind you of Bruce's book, and also to let you know, if you are in Ottawa, you can purchase the book at Barely Bruised Books, which is near the Ottawa campus, and is the only Indigenous-owned bookstore in Ottawa, or you can purchase it at Octopus Books, which is on the other side of the canal, 2 independent bookstores. So you have a chapter in your book, in this book, about Bruce, the Supreme Court specifically. So I wondered if you could address Wendy Hawks's question at the same time as maybe you want to tie it into that chapter in your book.
Well, I think on the issue of the Supreme Court, it's a prime example of systemic racism in the Canadian legal and political system. The idea that there are no qualified Indigenous people for the Supreme Court of Canada is completely wrong. The idea that Indigenous lawyers need to come up through the ranks, become a judge, a court of appeal, all the way up, and that, oh, it's too bad they've not had, or they've not been able to do that yet. Once they can, then there'll be people to appoint to the Supreme Court. Again, it's totally wrong. Non-Indigenous people have been appointed directly to the Supreme Court without being a judge. So it's just really important to keep this in mind. And then on the language issue, it is really important that there's a recognition of French and the French fact of Canadian history. There's no doubt about that. And this was highlighted by the Supreme Court in the recent Nadon decision, where the court had to decide if Justice Nadon, some of you recall, should continue to hold his seat on the Supreme Court. They decided no, because he didn't qualify as being from Quebec. What was interesting for me, and I've written about this in the book, is the reasoning that the court used. And it's completely understandable. It said, we need justices from Quebec because the court will be making final decisions on their rights, and there needs to be an understanding and a respect for their own legal traditions. So that's important. I don't have a problem with that. But my thought is, why doesn't that apply to Indigenous nations equally? Isn't that the rationale for why there must be Indigenous judges on the Supreme Court? Maybe one way to deal with this is increase the membership then on the Supreme Court. Have 3 Indigenous justices on the Supreme Court. There are courts across the world. They're not 9. They don't have to be 9. That's no magical number. And so I think that's very important, and that needs to be part of the conversation going on across the country.
And, you know, it's thank you for that. That's in the fix it. I think that goes in the fix it camp, Bruce. So I want to put some marbles in that one, in that jar. But you know, and to the point, to Brenda's point, you know, it's interesting to think about, because it's not just a language issue in the Supreme Court. It's a legal code issue, right? It's not just about speaking French. It's the fact that we have 2 legal regimes. You need judges to be able to adjudicate and who know the civil code. And then to build on your point, so why couldn't we create, in the spirit of actual meaningful respect for justice, judges who respect and know Indigenous laws to carry that through. So I'm looking here for more questions. People are asking on the technical side if there will be a recording. Yes, this will be recorded. And our friends in the Human Rights Center, who have taken such good care of organizing this event, will be sharing the recording. I'm seeing a question here about you opened up some voices here to talk about your chapter on allies, and somebody is asking, is there any way for allies to quiet those self-appointed arbiters without becoming that which they wish to destroy by choosing who gets to speak? And is there any way for allies to help take on some of the burden Indigenous folks have to deal with, but without the condescension or patronization which often accompanies those actions? So I'm putting this one in our fix-it jar. Your response.
Brenda, do you want to take a first shot at this, or you want me to say something first? I want to make sure we share the conversation a bit.
Please respond first, and then I'll jump in.
Okay, well, my thought is there is a really important role for allies to play, without a doubt. I always describe this as the cruel calculus of allyship. And the fact is that politicians looking out into the crowd, if they see and they can categorize these issues as an Indigenous issue, my experience is they're much less likely to take concrete action to resolve. If they see that it's crossed over, it's become a non-Indigenous issue, suddenly there's a lot more interest. And so I think that's one of the reasons it's important for non-Indigenous people to be out there and making themselves known that this is an issue for all of Canada, for the politicians. But I think in doing that, you really do need to be a good listener. I think lawyers are some of the worst listeners around. I always tell my colleagues, too much talking, not enough listening. And listening, whether you're a lawyer and ally, is hard. Listening is hard work. People think it's just a simple passive thing. You have to actively listen. And as an ally, I think you need to recognize if you're hearing something you don't understand, the problem isn't with the person speaking to you. It's probably because you're operating within a mindset, concepts, assumptions that are blocking out voices. And you need to really work on that. I can say myself, I work on this all the time. I'm definitely not, I fail a lot of times. It's hard listening. And it's hard being uncomfortable. And it's hard to understand sometimes. I have such fantastic clients who are so patient with me. Often the best times is they'll draw it out for me, because a lot of it times is really visual. And the patience and the understanding is amazing. So it's not like you can't do it, but you really have to commit yourself, I think, to be an exceptional listener.
Yeah, I agree with that. I think it's hard for people to listen. It's hard for them to hear hard truths. It's really hard for people to have to unpack everything that they've known and understood and learned about the world and start to face it in a different way. And we can see, probably in your field and in mine, we see those transformations. In my case, it's when students, have that automatic response of, how come I didn't learn this before? Well, there's a reason for that, but also you might have, but you've forgotten because you have all of these other pieces that have been a part of your life. And so, I'm highlighting this particular piece right here. I think it's not that we don't need allies. It's that we need people to stand behind us and not necessarily keep trying to get in front of us. We need people to take things at our pace and not be so demanding about the change that they want in the immediacy. And so again, I said a few years ago when we started, when the TRC calls to action came in, every university wanted to start implementing all of the calls to action, which is amazing. But the burden falls on Indigenous people to do all of the work. And I said facetiously in a committee meeting that, reconciliation was going to kill us because it's exhausting. The amount of work for it is exhausting. So it's trying to strike all of those balances and allow us to take it at our own pace so that we can regroup and plan and think and strategize, and then give us the resources that we need to actually make some of the changes happen. I need people to get me money. I don't necessarily need people to tell me what's wrong.
These are important points, and we have the privilege of being able to learn from Brenda, all of us at the University of Ottawa, and sometimes we're not very good learners. But she has extraordinary patience, and I have seen what the teams, especially at our Indigenous Resource Center and otherwise, have done to help the settlers on campus help themselves recover their humanity, our humanity, and also move towards actually being helpful. Instead of being burdens. We're arriving close to the end here, and I wanted just to, maybe we could take one more question. I'd like to leave a moment at the end for the director of the Human Rights Research and Education Center, whose team has graciously looked after all of the technical aspects of this event for us, to say a few words. Is there something that you feel, Bruce or Brenda, that question? I know that I see that there are still other questions here, and I'm sorry, I'm trying to go through them as best I can, but there will be a recording of this event. And I don't know if there's something, Bruce, that you wanted to address specifically from the Q&A instead of me picking and choosing.
No, thanks, Anush. I've not been able to follow both the QA and the chat at the same time,
Yeah.
so
Yes. Okay.
I
So
apologize for that. Yeah.
no, and
I just one point though. I think a point that I like to make, I think is important to make all the time. We really do need to see effective change. We really do need to hold government officials to account. We need deliverables. I was talking to people at my church back in Vancouver, the Unitarian Church, and they're saying, some of them were saying, you know what, should we keep doing these land acknowledgements? I don't know. It doesn't really seem to be doing it. And one of the suggestions that came up was, why don't we once a month, once every 2 months, begin and say, this is what we've done over the last month. This is what we've done to realize effective change. This is what we're doing. Like, show me the results. I love Brenda's point, show me the money. You know, well, show me the results. I really think that's what we need to be holding politicians to account. And one of the reasons I think that is because I fear the growing cynicism across the country. I know I may be discontent, Anush, but I'm not cynical. I think I'm a realist, but it's hard to fight off the cynicism. And particularly with young Indigenous people, I see it all the time. They get drawn into this based on the principles that are enunciated, and then they see the reality and they grow cynical. And it's hard for me to say, well, that's not justified. And I think that's our biggest danger, is that cynicism. And that's one of the reasons we really need results. Show me the results.
I think that's a wonderful point to end on. And I just before leaving, I would just like to give my own word of thanks to Bruce and to Brenda and to all of the audience members, and especially to highlight the work of Anne-Marie Tudorache, who has helped us make sure this event was accessible to French speakers, and to Henry Pitawanakwat and his beautiful Ojibwe that has been like a melody in my ear throughout. And I'd like now to offer the screen to a wonderful friend and a colleague and our director of the Human Rights and Research and Education Center at the University of Ottawa for some closing remarks. Over to you, John.
Thank you very much. Thank you, merci, and miigwech. Let me say on behalf of the Human Rights Research and Education Center that we are honored to have been able to help to host the book launch today of this important new book by Dr. McIver, and the discussion of today, and very honored by the collaboration and the collaborators we've had across the board. Let me thank, first of all, Dr. McIver for his work, for the clarity of thought and words that we all benefit from, both written and orally today. Let me say personally, I'm a strong supporter of a practical, let's fix it approach. I know that's not a panacea, but for example, your suggestions or comments regarding the Supreme Court of Council, this is the Supreme Court of Canada, this is definitely possible to address, conceptually at least, and we should raise those questions. Thanks also to my colleague, Professor McDougall, for her comments and the collaboration, and also with the Institute here at the University of Ottawa. Thanks to my colleague, Dr. Turjanian, for your enduring and tremendous effort and thoughtfulness, which inspires so many. Thanks to our Ojibwe interpreter and our English-French captioning translator. Thanks to the booksellers whom we've mentioned, who have made Dr. McIver's book available. and contributed. And thanks, of course, to my own colleagues here at the Human Rights Research and Education Center, Vivian Fernandez, and behind the scenes, Carolyn Fauché, who's done a great amount. And then, of course, thanks to everyone attending. This is part of the Human Rights Research Education Center's 40th anniversary and our effort to continue the long journey of bringing human rights into Canada, which was the origin of our center, inspiring and contributing practically to the constitutional reforms in 1981-82 in Canada, and specifically the Charter of Rights and Freedoms, with a view to fulfilling the great potential for everyone here and for full lives and dignity for everyone. Let me draw to your attention that spirit two forthcoming events next week on the 9th of December, which is, for those who may not know, the anniversary of the adoption of the Genocide Convention by the United Nations. We will have two speakers of ongoing genocides. There are a number of ongoing genocides in the world, including, the argument has been made, here in Canada. And we will have a woman Rohingya speaker, Yasmin Yula of the Rohingya community, lives in Vancouver. And we will have Mehmet Toti, who's a leader of the Uyghur community here in Canada, speaking about the Uyghur genocide. That's also the annual International Day for the Protection of Human Rights Defenders. So please join us for that. And on the 10th of December, the anniversary of the Universal Declaration of Human Rights, our colleague and friend Alex Neve will be hosting, I think, a fascinating talk, a discussion, a conversation with three Canadians who have been or are special rapporteurs of the United Nations Special Procedures System, Leilani Farha, Michael Link, and Francois Crépeau. So please look for that on the 10th of December. So finally, thank you again for this opportunity and for all the contributors. Thank you. Merci, Miigwech.